Hi guys, it's Kathy. I hope you're doing well. I was awake just a little bit ago. It took forever to find anything worthy for today's stream. So I worked a double, I got off, and then I just started looking through videos, and it took forever. And then I fell asleep right before we were about to start. Thank God Fozzie called me. What would we do without Fozzie? I don't know. We would sleep more when we shouldn't be sleeping. I was just real angry all night because something just ticked me off at work. So I'm going through these videos and I don't like any of them. I don't like any of the clips that I'm seeing because I'm, pretty angry. But anyway, I have some. So it's a little chaos. Judge Jacobs usually doesn't allow chaos. It's kind of weird for him that this is a little loud in this courtroom, but this guy, they're talking about a guy who has mental health problems because he got in a car accident, but is not incompetent. So we're not talking about someone completely incompetent here, guys, just so you know.
On community corrections, here's the allegation was that he let the unit battery die on one occasion. Then he had one approved movement in 24 April and then four unapproved movements in May of 2024. The arrearages have been satisfied at some point prior to or after this petition was filed. So the dilemma is based upon his condition. I've got correspondence from he requires significant accommodations to prevent falls. He has limited mobility from spinocerebellar atraxia type 6. This is in addition to the brain injury that he sustained as a result of being in an accident. Motor skills are diminished, vision's diminished.
We take a shot every time they say he was in an accident.
He's partially blind. He's been living at home with his parents. He doesn't drive and no longer drives a vehicle and hasn't been driving a vehicle and is really dependent upon his mother, Karen Upton, for day-to-day care. So it kind of in a tough position. I think it would be for him to go into custody would be pretty severe sanction on the borderline of cruel based upon his current medical condition. What he basically does now, he's at home and only goes to medical appointments when necessary. So also, I think one of the concerns was the issue based upon his TBI, traumatic brain injury, and his speech patterns, that he says things that aren't appropriate and in a penal facility or in custody may lead him to get himself into severe trouble.
So every time they lock him up, his mouth goes and it gets him in trouble. And it gets him in trouble with the police.
Or fights with other inmates, which was a concern of the physician, Dr. Waggers. So I don't know. I'm kind of relying on the court for some guidance here. The allegations of violations are not substantial, and there's been no new criminal offenses. And it's been filed. And typically, I know the state says, well, if there's new criminal offenses, no talk, no pass go. In this instance, I don't think there's that situation that has not been alleged in any document I've seen. So that's where we're at today with him. And it's also been kind of one of those holding patterns we've had for the last few months to see, how his medical condition would progress. And apparently from all indications from medical, it's digressing and that he's not getting any better. It doesn't appear that his long-term prognosis is that good.
So, but you don't have any good options either, do you?
Well, Judge, the option would be for you to say, okay, I know community corrections doesn't want him back. But as far as the ankle monitor is concerned, I really don't even think that's necessary. If it's the issue of giving the time that he owes, he would be basically ideal for just standard day reporting. Again, he depends on other people for transportation, primarily his mother. His mother is getting up in age and has even confided in me that she doesn't know how much longer she can continue to provide the day-to-day care. And at some point, he may have to go to a nursing home. But she's done it up to this particular point, despite her own medical conditions. So my request would be he make the admission, court orders him back to community corrections to serve whatever remaining time he has on day reporting. That's a lesser of the two. And his fees, like I said, have been all three up to date, so anybody that was eligible has been satisfied.
All right, thank you, Mr. McCall. Mr. Shaw, sending him from serving home detention with a violation, the day reporting doesn't sit right with me, but also I kind of understand he doesn't have the capacity that somebody else might have. What are your thoughts today?
Okay, so Judge, it's a complicated one on the surface, but realistically, it's not that complicated. Mr. Upton was on home detention this time. He's been with community corrections on these same exact cases numerous times, and no matter what he's on, he cannot complete community corrections. He's had all these issues and compounded issues the longer he's been allowed to stay out. Every time he gets a violation, it takes more than a year to finish it. He's gotten new cases in that time, and then he gets injured in that time. If he would have gone to prison and served these out on the first one, he'd be done, he'd be out, he'd be free. But we just keep recycling these cases with community corrections, and every time it ends up in failure within the first month or two. So it's not just the fact that he has some medical conditions. I understand that part of it, and it's unfortunate, and maybe nobody's a winner in this situation. But he's unsupervisable, as strict as that. Nobody in...
There's a couple people here in this chat that are unsupervisable.
community corrections, no matter what program he has or anything, is going to be able to supervise him, because he'll fail again. He will be back in front of the courts. I would have supreme confidence in that. Every time we get him, we try to work with him, and we just have failure after failure after failure. The fees, I know he said that they were taken care of. They currently are still outstanding. He has not paid the $1,104. But because of the fact that we've just had these cases go through the mill multiple times, I think it's just, at this point, it's time to just say it's too much. He can get the care he needs in IDOC. He has that opportunity, and he could be better off for it, having these cases put behind him and then not having to worry about stressing them in the future. But I would be very confident that if he were to go on any sort of community supervision, that he would end up back here.
Sir.
Yeah, Judge, in response to that, I mean, this goes back, I mean, we're talking about in 2021 where he had a traumatic brain injury where he was hurt. And from what I can see from that point forward, these were the issues with his inability to comply. However, I don't think there was any new criminal allegations during that whole period of time. It was simply procedural aspects, letting the bracelet die, not being in locations. The traumatic, with the traumatic brain injury, and I don't, God forbid that Mr. Shaw, anybody has to ever have that in their family.
Martha D bought me this top. Thank you, Martha.
And deal with that, has substantial issues with a person's ability to understand and to continue to try and do that. He depends on someone else to give him direction and that type of thing. The allegations here are 5 unapproved movements and letting the bracelet, in this particular instance, not go dead at one point. So couple that with what he's dealing with mentally, physically, etc. There should be at least some understanding that may occur under these circumstances. My personal belief is based on the community corrections position early on with him, is that they really didn't want him at any point.
It's not Julian.
And when the court would put him back on, were more inclined to not give him the benefit of the doubt than give him the doubt. So again, I don't know based on what he has on the shelf, that he will go to DOC. I don't think he will. So he's here in the local jail being treated, and he's going to have this treatment. And I assure you, I will ensure that he gets that treatment, and I will, if that's what the court decides to do, and make sure that the taxpayers of Clark County are going to pay that, because he is definitely, and we've got medical provider after medical provider that has said that based on his condition. So I know it doesn't necessarily set right with community corrections, or set right with the court. In the ordinary course, if Robbie Upton was anybody else and had done this, go, buddy, you're out the door. But this circumstance is unique. It's not a case that you're going to see on a regular basis and have to make this type of decision. But this is a unique set of circumstances that you're not going to come across. And if there wasn't for the medical proof, and if I need to submit it to evidence, I can, for the court to understand, but I've been reading to you exactly from the medical provider. And so that's why I think the court should consider a different option in this particular case than incarceration. It doesn't make sense.
Run into what is my option, because Ms. McCray, I don't know what Ms. McCray's going to ask me to do. I presume sitting the DOC, but we're also talking about an agreement somewhere, right? I mean, this wasn't a discretionary sentence, so I can't go back and undo a plea that Mr. Upton signed.
No, I think
it's true. The judge can't just go change what they plead to, because they agreed on it. So what does he do? He can't go to jail because he causes issues in jail. He definitely can't stay in community corrections.
I think you modified it at some point, Judge, to a certain. I don't have the history on all of it. I mean, I was just kind of reviewing it here, but I think
trying to go back and dig it out. But we're going back to what.
Sure. But part of this, Judge, is that yes, he did have the issue with the accident that left him worse for the wear. I mean, no one's denying that, and that he's in worse condition than he was when he first came to us the first time. The problem was he had that accident while he was out in the community, not being supervised, waiting for a violation of placement. Before that, he was with us, and then the violation occurred. And the one before that was the one where he was committing new crimes and had multiple amendments to his petition because he kept committing new felonies. And then he has the accident while out on all of that. And then he hasn't committed something since then. That's great. He hasn't committed something since then, but he was doing it before that. And then he's been with us multiple times since this accident and has had multiple more petitions to revoke. So it's...
Michael, it sounds like he passed grade 10.
And if he's not able to make any decisions for himself, he'll never be able to sign terms and conditions for any sort of placement under that guidance to where he can say, I understand the rules that are required of me. If you're saying he can't understand those, then he cannot sign our terms and conditions.
I didn't say he was incompetent. I said he has a traumatic brain injury, which affects his cognitive abilities. Number two is, while that was the issue that presented itself then in 2021, over the course of time, while this is for the last 4 years, other conditions have presented themselves that are in addition to the traumatic brain injury, which have caused him additional problems, not only with his eyesight, with his ability to walk, other things that have happened over the course of time. The condition which I just presented to the court was not a condition that existed back in 2022 when he first went on. It has progressed over time. His condition is deteriorating over the course of time, and it may be a slow roll, but it is happening daily for Bobby Upton. And that's the difference between what Mr. Shaw is saying now, is that he had that traumatic brain injury in 2021, but that's just a part of the puzzle that continues to progress over the course of time. And it's not as if that were the only condition he had, the only condition he has now.
Ms. McCray, let's stay away on this one, please.
Judge, I mean, there's really no good answer here. I understand what Mr. McCall is saying, and I understand the nature of the case has changed over time due to the nature of the injuries that Mr. Upton has sustained. But that doesn't. I understand what Mr. Shaw is saying too. He's just not a good candidate for community corrections. Despite what Mr. McCall just said, it sounds like he's indicating that there's a level of incompetence here for Mr. Upton because he can't make decisions of his transportation. He can't make decisions on behalf of, his medical necessities. He can't make decisions on his own. He relies on his mom for everything, and he's not going to be able to comply with these rules that he is required to follow if he's on community corrections. So it sounds like he's just not a good candidate for community corrections any longer. And I understand that there has been a significant change in Mr. Upton's mental capacity since he signed up for community corrections, but to essentially sweep under the rug every violation that he's endured while he's been on this case is really not doing much for today's hearing. It's really not doing much for the end result for Mr. Upton. Essentially, what it sounds like the defense attorney is asking for is for a modification of the sentence for Mr. Upton to accommodate for his traumatic brain injury. And I understand why he might be asking for that. That's just not what we're here for today. I would assume what we would have to do is prove that there's been a violation, have the court make a determination, have the court impose a sentence, and then I suppose make a modification at that point to accommodate then. But the state's going to go ahead and agree with Mr. Shaw that he's just not a good candidate for community corrections. He's not going to be able to comply with the terms and conditions that are required of him. And I think we're crossing issues today for what we're supposed to be doing for today's purposes. I understand that we're looking at this long term, and I appreciate what Mr. McCall is trying to say. I just think that for today's purposes, we're kind of getting ahead of the game and trying to move around the executed sentence that he's looking at, if that makes sense.
Two responses to that, Judge. One, I think that the court has the ability to do the least restricted placement under community corrections if they order that, number one. Secondly, if what Mr. Shaw is indicating, and if that's the case, then I think that a motion, I should file a motion for competence to determine whether or not Mr. Upton can, in fact, if the court was inclined to do that, even sign the conditions in terms of a placement for day reporting or the terms and conditions of that. So that's kind of a twofold issue. One, if you do it, can he do it? If you do it, can Mr. Upton do that? So that may be an issue that we take up down the road. But as far as the ability, I think the court has the ability. It's not a modification of the sentence. It's a modification of the level of type of placement. The sentence is still in place, and the time that he would have to give through whatever placement the court determined would be the same as it was when the petition was first filed.
So I do have one answer. The 1720 case was pursuant to an agreement. I cannot modify that. Good news is he only has 6 days left to serve on that. I don't know which one I'm on right now. This was on 238. It was blind.
Just give me if you can go down at nighttime. Get out in the morning.
We've got to look back.
Go to doctor's appointments. Ask him that. Say, Judge, can I say something? Can I turn myself in at night? Yeah.
Karen, quit talking.
The defendant and his mother. Okay, here's the courtroom. They're like right off camera right here. Hi, Sandra.
Go back farther and see if this one was an agreement or not. Here's the agreement, file 864, and it's blind. So I do have the discretion to do a whole lot here, including a second modification probably, right, Barry?
Yes.
All right, I'm not ready to do that today. I got to sit and chew on this for a bit because I have a hard time morally rewarding Mr. Upton after a violation. I understand cosmic sense of justice. What I do is very little today. So I get that. So let's set him for April. Barry, you give me some options of what I can do and what you think I ought to do. And let's set this for April the 1st, but I might just rule on something, give the state an opportunity to present something as well. We'll see. So April 1st, as of now, on Mr. Upton on all 3 of these cases.
Is that the afternoon again?
Yes, sir. And submit essentially a proposal, maybe with an order, and then Ms. McBride, if I'm inclined to sign anything without setting it for a hearing, I will certainly let you know and give you the opportunity to submit something if you want to submit. I won't just sign something that comes across my desk.
I'm sorry, Judge. What are you referring to?
Barry's gonna propose a couple things, and if I think they look reasonable, I'm not just gonna sign them. I'll give you and let you know that I want to sign them and see, either let you respond in writing or put it on the record or whatever you want to do.
Gotcha. And I mean, I'm kind of on board with figuring out the issue of competency because I don't feel like we can really do very much. I'm inclined to have this hearing today and have Mr. Shaw testify that this happened and there's a violation. But if Mr. Upton's input is, he's got that right, I do think that we should make the determination before going forward because I really do think that what happens will fall on whether or not he's deemed incompetent or not. If he's not, then, I'm going to be requesting a full revocation, obviously, and going that route. And if he isn't competent, then I think that does change the arena quite a bit.
I think there's a couple, and again, I'm not going to beat this around much longer because I understand what you're doing. But I mean, I know there's a mental competency aspect of it, then there's a physical competency part of it that I think comes into play as well. And so I think that's the main issue for us. But if I need to file a motion,
Physical competency? So there's a mental competency and then there's a physical competency?
court directs me, say, hey, it could be in your for the court's best interest to know if he's competent or not. I can do that and try to get that done. Don't know if I can get it done by April 1, but I will certainly give it an opportunity, and we would ask the court to direct us to who the psychologists are that the court would be inclined to rely on, whether it's Dr. Anderson or Dr.
So competence would be, I guess, is he competent to admit or deny today? Wouldn't necessarily be at the time. I'm happy to do that too. We'll workshop that. We'll figure that out.
Yeah, let me figure that out too. I'll submit.
As of now, Mr. Upton, I'm setting you for April the 1st at 1:30 p.m. Maintain good contact with Mr. McCall. We'll see what we can do and where we go from there.
Yes, sir.
All right. Thank you, sir. Thank you, Mr. McCall.
Thank you.
All right. I've got the main.
Different than this.
Okay.
Maybe ask that they be reduced. Different than this.
Okay.
Maybe ask that they be reduced or something.
All right, Your Honor.
Got it?
Yep.
Okay. Your next court date is
February 4th at 2:15 PM in DST.
February 4th.
February 4th, next Tuesday.
Thank you.
All right.
Before you call the next one really quick, Mr. Hunter that we did a little while ago, he's asking for the key police.
Oh, yes, I meant to do that. People versus Deaver. Jet Deaver, 25 CR 384.
Hello.
Your name, please, sir?
Chet Deaver.
All right. Sir, did you watch the video advisement of your rights?
Yes.
You have any questions about that?
No.
All right, the charge in your case is one count of assault in the second degree. That's class 4 felony. Possible penalties are up on the chart there. Any question about the charge or the possible penalties?
No, sir.
All right. All right, booking bond is 10,000 people.
Yes, Your Honor. As far as reason to PC affidavit, we do have elevated fear for the victims in this case, especially with the acts of strangulation. So we believe a casualty property bond will be appropriate here in order due to the danger to the community and to the victims that the defendant poses. We do note there is a lack of criminal history in Colorado, but it seems to be he's only recently moved here. I think there's a longer history of his ties possibly in Montana. And so it seems it might be a lack of ties to this community. And so I believe there is a higher likelihood that he would not be compelled to show to court with that situation. So would cash surety property be appropriate here?
All right, defense.
Yes, Your Honor, I would ask for a supervised PR bond in this case. I would note that pretrial services, in other cases, I have seen them indicate that there's out of state criminal history, but they didn't. They said that case history was found, and that is consistent also with my searches. So I think given that there's no criminal history and then the CPAT score from pretrial services is as low as 3. And so I think that just indicates that he's not a danger to the community at this time. And then I would also just note that he did indicate that he's unemployed at the time. So just any amount of bond would be equivalent to a no bond hold in this case, given that he has limited financial means. And so given that this is the first offense, I would ask for a supervised PR bond.
PR bond. Your Honor, can I get a supervised beyond bond? Yes, let me. Stressed.
That's what I'm trying to decide right now.
Yeah. Is the screen frozen?
They're
That's what
thinking.
I'm reading.
It takes a while for some judges to think. That cat breaks my heart every time. Every time. The past owner declawed pity, so it just is so hard. In the bathroom, of course.
Court has reviewed the PC affidavit. I will note the booking bond is 10,000. That's the standard on a felony for crime of violence. I mean, there are obviously some other issues at play here. But the people who work at this facility have a right to be protected and not be
Absolutely,
assaulted.
Judge.
They're there to try and help people.
I understand that.
And so I'm not going to set it at 10, but I'm also not going to grant a PR. I'm going to set it at 3,000 cash surety property.
What does property that do?
Well, if you have property, you can put it up to post your bail.
Oh, I haven't got any. Okay.
I don't got
Okay, next court date.
anything.
February 5th at 1:30 PM in Division DST.
Okay, thank you. People versus Frey, Carmine Frey, 25 CR 252. Thank you, sir. Did you watch the video advisement of rights?
Yes, sir.
Any questions?
No, sir.
All right, in let's see, 25 CR 252, the charge is one count of motor vehicle theft in the third degree. That is a class 5 felony. Any
So when I was growing up, I always thought grand theft auto. I thought stealing a car was grand theft auto. And it was a really, really big deal. And you would go to jail for a long time. If you stole someone's lighter, not so much if you stole someone's car. And I was told that it came from back in the old days when if you stole someone's horse, like you would get hung for that. But grand theft auto isn't even, they don't know, I've never even heard a judge say grand theft auto. It's just stealing a car. It's a class 5 felony. A class 6 felony is the lowest felony you could possibly get. So it's not a big deal. I mean, it's a felony, but it's not what I was taught. I was also taught in the 80s that a lot more people would offer me drugs, and I have to say no to them. But you know what? No one offers me drugs.
questions about that charge or the possible penalties?
No, sir.
In 25 CR 239, the charges are one count of identity theft, class
Just
4
say
felony,
no.
and one count of criminal possession of a financial device, class 2 misdemeanor. Any questions about those charges?
No, sir.
True.
All right, booking bonds are set at 3,000 in each case. People?
Your Honor, I would note that there's, we, 5 open cases, where he has no bond holds from Division Z.
You have no bond holds?
Yes, Your Honor.
Defense?
I believe he's being seen on those cases either tomorrow or the following week, so we'd still be asking to argue.
Well, Your Honor, with those no bond holds, it appears that, here's Mr. Frey or Mr. Fry, excuse me. He's already had a PR bond revoked in the 22 JD 288. He had 4 failure to appears, and 3 failures to complies. In the next case, he had 2 failure to appears and 3 failure to complies for he had 23 JD 890. In the third open case, 23 JD 572, he's had 2 failure to appears, 4 failure to complies. 24 JD 976, he's had.
Are they though? Are they? I know we hear stories of, little children who get eaten by alligators, but are they really that big of a problem? Or is that just such a crazy story that it's in the newspaper, but it rarely ever happens?
To comply there as well. And then finally, in 24 JD 378, another failure to comply and a failure to appear in that case as well. So, Your Honor, this is just evidence that the defendant does not either have the willpower or the ability to show up to court when required to do so. Also, going by the charges before us today, these are similar charges to what he has in these open cases, especially the motor vehicle theft.
Right.
So I believe this demonstrates a continuing danger to the community. And with that danger to the community and the failures to comply and failures to appear, I think a cash surety property bond would be appropriate there.
Defense, you might want to consider waiving or reserving.
Honey, please listen to the judge when he says, don't bring up bond right now. Do not bring up bond right now because you're ruining his chance. Now you have to go to the next hearing, and then you have to put them on notice that you're going to bring up bond at the next hearing. You just lost him a whole bunch of days if you do. If you talk about bond now.
Just so you know, on 25 CR 252, he's on the no bond on that one because he failed to appear for bond and advisements.
Ah. Okay.
I'm gonna go ahead and still ask for a supervised PR bond. I believe that he needs more support than he can get while he's in custody. I did speak with his juvenile attorney, and he was previously found incompetent, which led to the dismissal of a couple misdemeanor cases. And I do know that there's currently competency proceedings in his current cases. And so while he has turned 18, I would also note that the GAL in his case has remained on due to diminished capacity concerns. And then ultimately, Mr. Frey is very limited financially. While he just turned 18 last month or just a month ago, he is currently unemployed, but maybe
Pitfall.
he might be able to get disability. And he currently does live who does currently receive disability, but I think their whole household is pretty limited financially. So putting a cash surety bond on this case would ultimately be equivalent to a no bond hold. And I, again, would just reiterate that he does need more help than he can get while he's in custody.
Counsel, I don't disagree with anything you said. And if he'd actually show up in court, he'd probably get that help. But he doesn't. And
That
the
was
problem
an
is whether
awesome
he's dealing with a
game.
mental health issue or
Awesome
not,
game.
the people of this community should not be subject to his thievery. Stealing people's cars, stealing people's personal identity, credit cards, that sort of thing. And until these other issues are addressed, I think he is a danger to the community. Bond stands at 3,000 each case. Next court date?
February 11th at 3 p.m. in Vision DST.
I know he's only 18, but there are consequences to actions
People
like
versus
that.
Harris.
All right, I recorded this in January, January
Rocky
27th.
Harris, 24 M7.
Oh, no, that was my Discord.
588.
Rodney,
Please, sir.
Rodney Harris?
Thank you. Sir, did you watch the video advisement of your rights?
Yes, sir. Yes, I did.
Any questions?
No, no questions.
All right. Well, this is, I think it's.
Oh my God, guys. So, we have this commenter who comments on every single video multiple times. Yep, it's awesome. And because I was so late today, I think she made it. Because she's here a lot, but not all the time because of how crazy my hours are. And it's Martha's birthday too. Guys, it's Martha's birthday. Martha, happy birthday. I'm so excited for you. I hope you get something nice. If not, go buy yourself something nice for your birthday. You can do that. You're allowed. I found out. Happy birthday, love. Thank you so much for all your comments on the videos. Thank you.
Summons, you're probably being held on something else.
Yeah.
Yes, that's correct, Your Honor. And I would be asking to leave Mr. Harris on a summons in this case.
Oh, yeah. I'm planning to do that.
Thank you.
So you're not actually in custody, but let me just tell you, as a courtesy, you've got a second-degree criminal trespass. That's a petty offense. Penalties are up on that chart in front of you. And you've got a possession of drug paraphernalia, which is also it's a drug petty offense.
Yeah.
And we just called this in today because what we're going to do is set this case with your other stuff so that everything can get dealt with together.
Yes, but is Martha physically competent?
Y'all put it in the other courtroom?
I'm sorry?
What y'all putting this is moving to the other courtroom?
Mr. Harris, I'll come visit you next week and we can talk about that. Okay?
Mackenzie
Okay,
Green.
okay, that's
I
fine.
wonder
just
if
didn't
she's
understand what
related to
you're
anybody I
saying.
know.
Yeah, for now it's gonna be in a different courtroom in Division G, but I can talk to you about if it's gonna go up to your other division, okay?
I don't want it to, but yeah, it's fine. I
Okay.
understand that, yeah, for sure.
Yeah.
Sounds
They'll get
good.
it all, your public defender get it all sorted out for you.
All right, for sure.
All right, next court date.
February 7th at 11 a.m. in Division G.
All right. Okay, we'll get you that court date. Thank you, sir. What happened with Mr. the older guy? Yeah, McDaniel.
He is ready, sir.
Okay, let's recall him. I know he's been sitting there for a while. Mr. McDaniel, come on back up. 25 CR 387.
Yes, I'm George McDaniel.
All right, Mr. McDaniel, you read through the advisement of your rights, did you?
I did read through it as well as I could. My eyes are not very good and I didn't have my glasses with me, so I couldn't
All right.
really understand all of it. But I do understand enough to tell you that there's a lot of problems with the way the housing company reported it to the police and what the police interpreted. My wife and I have been.
Okay, now hang on. You don't want to talk about that.
Okay.
We do
Not
want to
yet.
talk about the charges.
Pardon me?
Yeah.
Do I accept
just-
the charges?
Let me get through these. Let me get through the advisement part, and then we'll talk about what to do.
Okay.
So the charge in your case is one count of crimes against an at-risk adult. This is just an allegation at this point. It is a class 6 felony.
I do not 100% agree with everything that's done here, but I'm going to tell you something to remember at the end that will make you feel so much better about this outcome.
I don't know if you can see the board from there. Maybe one of the deputies can help you. There is a chart up there that tells you what the possible penalties for felony 6 are.
6.
Can you see that board?
Okay.
Felony 6 is the lowest
an
possible
F6.
felony.
I see that board.
Okay. So it carries both the possibility of prison time and fines. I'm not saying that's what you're going to get. I'm saying that's what the possibilities are. So you understand all that?
I have pretty good.
You understand the nature of the charge and the possible penalties here?
I understand the nature of the charges. However,
Okay, great.
major thing that does affect the decision that I make, and that is that my wife has very severe dementia.
I know, I understand. I read the PC affidavit.
Okay.
So we're going to address all this. Let me ask, are you requesting cash surety or PC? PR.
PR, Your Honor.
And defense, I assume no objection to PR here, given the
Oh,
circumstances.
thank you.
Um,
Hi, Zach.
so,
Hi, BI.
Mr. McDaniel, here's what I'm going to do. I'm going to grant you a $1,000 PR bond. What that means is you're just going to sign a paper that says you promise to come back to court to address this, and then you don't have to post any money. Okay?
Well, sir, that is not, Your Honor, that is not my concern. My concern is that I basically take care of her through
I'm getting to that next.
one of those, yeah.
Okay.
Right.
I'm also going to, now there is a mandatory protection order that enters in this case. And what, in your case, what that is going to be is that you cannot assault, molest, harass, intimidate, tamper with the victim or any witness in this case. I am not going to restrain you from seeing her.
So he assaulted his wife, who has severe dementia, and the judge is not going to put a no contact in place.
I'm not going to restrain you from communicating with her. I understand her condition. I understand why you want to be with her. But you have to be careful when you're talking to her. The best thing I can tell you is you cannot go hands-on with her. You can't grab her, push her, pull her, any of that stuff. If there's an issue, you need to deal with the staff. I understand you've been married a long time and a lot of this is probably second nature, but
I understand that, you've been married a long time and, assaulting her is probably normal for you by now, but you're not allowed to do it.
situation has changed some. So you got to be careful about this. That's all I'm telling you.
I understand, sir.
All right. So the protection order, and people can object if they want, but.
No.
I
All
object.
right. So I'm going to basically vacate everything except the no harassing contact section. Then, Mr. McDaniel, we're going to give you a new court date.
Okay,
And the DA, the prosecutor will decide what they're going to do with this case. Whether they're going to prosecute it or not, what kind of offer they might make you, all of that stuff. They'll figure out going down the road. If you want an attorney, you need to apply for the public defender. They represent you while you're in custody, but you're going to be released today. And
okay,
if you want them to help you, and I strongly recommend you get their help. Then you need to get an application and fill that out and submit it to the public defender.
Okay.
Okay?
All right.
All that makes sense?
So Debbie figured it out, just like I did. She's in a home, so she has supervision. So he also has supervision. So she's not alone with him. So that made me feel a bit better. Hey Walter, how are ya?
That makes more sense than what it was, yes.
Oh, I know it is. And hopefully you all can find a way to work through this. But I also don't want to keep you away from your wife.
Thank you very much.
Okay, next court date.
February 10th at 1:30 PM in Division DST.
Okay, and they'll give you a paper with that new court date on it.
Give me a paper, yes, okay, very good.
Okay, thank you, sir.
Thank you.
People versus Moury, Jason Moury, 24 M6848.
He's going to be a tablet at the end.
What?
Jason Moury is going to be a tablet at the end.
Oh, great. Okay. People versus Moore. Elaine Moore, 24T8967.
She went back. She's a refusal.
I think the tablets at the end are people they couldn't bring in front of the judge for some reason.
$200 bond. Okay.
Pity pie.
That was the one that was yelling in the courtroom, sir. So you had to...
Okay. All right.
That's why I think that.
People versus Rush. Kristen Rush, 25CR291.
JK, you would be
Name, please?
disruptive in a court. I want to go
Rush,
to
did
court
you
with
watch the video
JK
advisement of your
so
rights?
bad.
Yes, I did.
Any questions about any of that?
No, sir.
All right. The charge in your case is one count of conspiracy to commit aggravated robbery, class 4, felony. Penalties are up there on the chart in front of you. Any question about the charge or the possible penalties?
No, Your Honor.
All right. Booking bond is set at 3,000 people.
Yes, Your Honor. It's the nature of the charges.
I'm sorry, there's also a menacing class 5 felony.
Yes, Your Honor, that was, yeah.
Correct. Go ahead.
Yes, Your Honor, with although there is a, lack of, criminal history, we do have fear for the safety of the, community in general, with these charges of the, conspiracy to commit aggravated robbery and the felony menacing, with weapons involved. So, Your Honor, I believe a, cash surety property bond would be appropriate here, along with the relinquishment of any weapons, that might be in his possession at this time.
Defense.
Yes, Your Honor, I would be asking for a supervised PR bond in this case, or a reduction in the bond if the court's not willing to grant a PR bond. As the district attorney noted, Mr. Rush doesn't really have any criminal history. So the recommendation for a cash surety bond is based only on the level of charge in this case, as the district attorney said, and at this point, those are allegations to which Mr. Rush has the presumption of innocence. Like I said, he has no real criminal history and he does seem to have strong ties to the community. He's had a local address for over a year and he does appear to have a local phone number as well, indicating that he is from this area to my knowledge. Mr. Rush has also had a job in the oil field with Hilmrich and Payne for 2 years now, indicating that he has had stable employment, another tie to the community. And so based on that information, I think that there's no indication that he wouldn't appear for court to resolve these matters. And so I would ask the court to grant him a supervised PR bond today so that he can address these matters out of custody.
Yo, this camera is great. I am covered in cat hair. You can't see it. That one was Pity Pat. Pity. Pity pie. Pity. Judge's thinking. He's thinking hard on this one. I like judges that stop and think.
The rest you're 20 years old, 21?
Yeah, I'm about to be 21.
And no criminal history. And the first charge you catch is aggravated robbery. Conspiracy. Mr. Rush, given your lack of history, I'm going to set your bond at 1,000. Instead of 3,000. But I got to tell you, this is not a road you want to go down.
My cats have pulled my green screen down at least 4 times.
Because people with guns end up getting shot and killed. I mean, I've been watching a juvenile case involving car thefts with a bunch of juveniles. Over the last 2 years, there were like 7 or 8 of them. 4 of them are dead now. 2 are in prison.
Juveniles.
Just not a direction you want to go, man. Next court date?
5th at 1:30 PM in Division DST.
So February 5th?
Yeah.
Correct.
February 3rd, next Monday.
It's today, guys. February 3rd.
Oh, I'm sorry, February 5th. Sorry,
Oh,
my
never mind.
mistake.
My mistake, guys. It's not today.
So it's the next Wednesday. Okay, thank you, sir. People versus Salsberry, Stephen
This
Salsberry, 24M
is
3004.
Colorado. Division G.
Where
I
Salsberry?
don't
Stephen
remember.
Salsberry.
I'm sorry.
All right,
It's
did you watch the
Colorado.
video advisement, sir?
Yes, I did.
Hi,
Any
Mother.
questions?
No.
All right, the charge in your case is 1 count of false reporting to authorities That is a class 2 misdemeanor. Penalties are up on the board.
Okay.
You got a ticket for this. You failed to appear in court on the date on your ticket. A warrant was issued, bond was set at $400. That's why you're in custody.
Okay.
And let me explain something, Ms. Suffolk.
I think
You're
it's
in jail on a
Garfield.
case nobody goes to jail for. Because you just didn't show up in court.
Okay.
That just doesn't seem very smart, does it?
No, it doesn't.
If I give you another court date, you're gonna show up?
Yes, I will.
Because if not, the bond will go up to like $800 and then there won't be any PR bonds. And then you'll have to post a bond to get out. So just show up.
Okay, I definitely will.
PR bond set in the amount of $400. New court date?
February 7th at 11:30 a.m. in Division G.
Okay, we'll get you that court date.
Okay, thank you.
Thank you.
And I will be going home today.
Yeah.
Thank you. Thank you.
People versus Shamwell, Robert Shamwell, 25 CR 388. Name, please. Where is he?
Sorry, sir, who did you call?
Shamwell.
Hi, I'm Kathy, Judge.
That was a refusal.
All right. People versus Simmons, Daniel Simmons.
He's coming up.
2014-9895.
Daniel Simmons.
Thank you, sir. You watch the video advisement of your rights?
Yes, sir.
Any questions?
No.
Let's see, Ms. Simmons, this is just a summons. It's 2014-9895. And the summons alleges, basically a hit and run, duty to give information. It is a class E. Not on here. They know what level of offense that is.
You can see, I believe it's, into.
I'm thinking it may be a class 2 misdemeanor traffic. Class 2 misdemeanor traffic offense. Possible penalties are up on the board. This is just a summons. You think you have other cases? So we wanted to call this, get you advised, and get this case over with your others.
Yes, Your Honor, and I would be requesting if the court would impose a nominal bond so that Mr. Simmons can accrue credit while he's held on his other case.
Okay,
Thank you.
so you're moving to revoke the summons and set a bond,
If the court's willing to impose just a nominal bond, then yes.
be $100. I don't
Okay,
know why.
then I'll just leave it as a summons, Your Honor. Thank you.
Okay, okay. I'm willing to push the legal fiction so far, counsel.
Okay, thank you, Judge.
All right, sir, your next court date is,
February 7th at 8:30 a.m. in Division E.
okay, thank you, sir. People versus Christopher Valdez, 20M 6330. Your name, please?
Christopher Valdez, Your Honor.
Mr. Valdez, did you watch the video advisement?
I did.
Any questions?
No, sir.
This is also a failure to appear on a ticket. You were charged with possession of 4 grams or less of a Schedule 1 or 2 substance. That's a drug misdemeanor 1. Class 1 drug misdemeanor. And then they gave you a ticket for that with a court date you failed to appear for that court date. So they, issued a warrant for your arrest and your bond is set at $700. So can you post that?
No, sir.
Okay, well, why didn't you come to court?
Currently, what, I'm sorry?
You what?
I currently just recently moved. Have a job starting on Monday. I thought I had taken care of this. It's,
moved.
it's like
Got a job starting on Monday. I didn't know this was a thing. I thought it was over.
2020, I believe it was. I was with my ex-wife at the time.
My mom's sick.
I have no answer for. It's I think at the start, onset of COVID, and
COVID.
No, it's not COVID. We're 3 years after COVID. Don't keep bringing that up.
No, I apologize. I know I was.
No, and Mr.
Mr.
Valdez, you're talking yourself out of a PR bond here.
I
hear a ton of excuses. Getting arrested is inconvenient.
I forgot.
And Your Honor, I would note, I believe he's got an open warrant out of a Teller County case, 16M3646. That's a domestic violence charge.
You got a DV warrant out of Teller.
Yeah, I have a PR bond on that as well.
No, you don't get a PR bond on a warrant. It's an active warrant.
I was told that I have a PR bond.
Your Honor, he actually does have a PR bond on that warrant. I did find that in the court records. That's accurate. He's not held on that case.
All right. What was the warrant for?
The warrant was for hearing on revocation. This was a class 3 misdemeanor from 2016. I believe he may have been on unsupervised probation and was mailed a notice of revocation. It sounds like he may have moved, and so that's what that warrant was from.
So you moved and didn't tell them where you moved to, which is another violation. You're supposed to tell them where you moved to.
I failed to do so. I wasn't aware that I had to.
In your paperwork.
Yeah. I must have lost it in the move.
You're just not paying very close attention here.
I know. I got personal issues, health issues that limit me from focusing.
Yo, he had that excuse ready though, real quick. Sir, it was in your paperwork. Oh, must have lost that in the move.
Mr. Valdez, are you living at an address now that you're going to be staying at for some time?
Yes, ma'am. I just recently moved there. My mother just passed away, and I moved out of the house, and I'm currently.
So, Your Honor, I would just note this charge is 5 years old. Mr. Valdez has not had any new criminal charges since this day.
He's physically incompetent to go to court. To go to jail, good judge.
It sounds like he's in a bit of a more stable situation now than he was at the time, so I would just ask the court to give him a chance to appear on a personal recognizance bond in this case.
I'll give him PR. I'll convert it to PR, but it's going to be supervised and he's going to do randoms.
Okay, thank you, Judge.
So, Mr. Valdez, I'm going to convert this $700 bond to a PR bond of $700. It is.
I would definitely go to jail for misusing Windows 11.
Going to be supervised by PR, pretrial services. And I'm going to order that you do random drug testing at least once per week.
Okay.
You do that, you stay out on a PR bond. You
Can't
miss
do
those,
testing.
you don't do them.
He lost his urine. He
And
doesn't
that's
know
my
where
concern
it
is you seem to have trouble remembering this kind of stuff.
The medication that I take for my heart, sir, I kind of get fogged memory and things overlap. That's no excuse. That's just part of the issue that I have with me being Christopher Valdez.
Yeah, well, the drug use might have to do with it too.
I've been clean since. My first one will be clean.
Oh, good. Then the randoms won't be any kind of problem.
No problem at all, Your Honor.
Okay. PR bond, random testing, 1 per week minimum. Next court date.
February 7th at 11:30 a.m. in Division G.
Okay. See you back then. Don't miss that.
Well, thank you, the court.
He already forgot to come, Judge. Hi, Nan.
People versus Zaylen. Marzalen 24 CR 5348. Name, please.
Mark Zalen?
Mr. Zalen, did you watch the video advisement of your rights?
I did.
Any questions about that?
No.
Charges in your case are 1 count of assault in the 2nd degree. That is a class 4 felony. 1 count of crime of violence. That's a sentence enhancer. So that means the sentence on the assault would go up. Typically it goes to from the midpoint of the sentence to twice the maximum. 1 count of harassment, class 1 misdemeanor, 1 count of menacing, class 1 misdemeanor. You understand the charges with the possible penalties?
Yes, sir.
All right, booking bond is set at 10,000 people.
Yes, Your Honor. We do note that there is we don't see any criminal history for Mr. Zalen. However, the PC affidavit does raise some concern for safety in the community, and especially with the use of use of weapons in this case, and the threat of arson. So, Your Honor, we believe with this raised fear for the safety of the community and the victims in this case, we think a cash surety property bond would be appropriate, even with the lack of prior criminal history.
Vince?
Yes, Your Honor,
Bye,
I
sweetie.
would
Hope you're feeling
reiterate, as
good.
the district attorney said, Mr. Zalen doesn't have any criminal history whatsoever. It appears this is the first time he's ever been charged with anything. The PC affidavit does indicate that
Ja, we love you. Hi, Ja.
substance use may have been involved in this circumstance, so we would be requesting a supervised personal recognizance bond with monitoring so that the courts can enforce keeping an eye on any substance use issues Mr. Zalen may be experiencing. I would note that in addition to not having any criminal history, he does have a 0 CPAT score, indicating that he is employed at this time, although I don't have specific information about his employment. It appears that he's lived in the area for a long time and has a partner here. So I think that he has strong ties to the area as well as his lack of criminal history. So in order to address the potential substance use concerns as well as to reflect his lack of criminal history, I would be asking the court to impose a supervised PR bond in this case, and I would be requesting at least a bond reduction if the court's not willing to do that.
I'm always excited when you come near. I'm sorry, ladies. I didn't know he was taken. Oh, it is Argus
Court has reviewed the
Filch.
PC affidavits. I understand this is Mr. Zalen's first offense, but the only way I characterize this is he's out there terrorizing people, threatening to burn them, threatening to shoot them. And it may all be drug induced, but that doesn't make it any less terrifying for the people he was around. Are you working, Mr. Zalen?
Yes, I am.
What do you do?
Right now, I'm an Uber Eats driver.
You're what?
I'm a delivery driver for Uber Eats.
Oh, okay. How old are you?
40.
I'll set bond to 3,000 cash surety property. And that's mostly because you don't have any prior criminal history.
Thank you.
Next court date,
February 10th at 2:15 PM in Division DST.
All right.
You call the news room, they have something on their laptop, so if you still have Mr. Maury, oh, here we go. This one, I think they're ready with him.
We're doing him on the tablet.
Yes.
Are we ready on Mr. Maury?
We are, Your Honor.
Mr. Maury, state your name for me, please.
Good morning. You may do any why.
Mr. Maury, did you watch or did you read an advisement of your constitutional rights?
Yes.
You have any questions about that? The charge, so here's the deal. This was a ticket, 24M6848. And it was a ticket for possession of drug paraphernalia.
Okay.
You failed to appear on the ticket. There was a date on the ticket for you to come to court. You didn't come to court. They issued a warrant. And you were arrested on the warrant. The bond is $100, but counsel, looks like he's on a parole hold.
Can I go ahead and plead guilty to that?
Yes, he is, Your Honor.
Should we just set a court date?
Thanks, sir.
I mean, he's not gonna get out. Even if I convert it to 100 PR, he's not gonna get out.
Quit yelling at the
Yes,
judge.
to reserve.
You're on a parole hold. You're not going anywhere.
My parole officer is already aware of this. Silver linings.
I'm not gonna argue with you about it, sir.
Okay, thank you.
All right, let's set a court date. Hopefully we can get this resolved.
February 7th at 11 AM in Division G.
February 7th, 11 AM. Hopefully you can get this one, take care of, get it behind you.
I feel strongly, Linus. I feel strongly that I can figure out laws in your country like that. So I shall be your lawyer.
Okay, thank you.
And that cat is going to jail because of your juice.
Are we ready on? Angulo?
This is Angulo, present, Your Honor.
All right, 25 CR 382.
He's a present, all right.
Angulo, did you watch the video advisement of your rights?
Yes, Your Honor.
You have any questions about that?
No, Your Honor.
All right. Depends, how do you want to waive further reading or advisement?
Yes, I would, Judge. Thank you.
All right. As to bond, people, I've read the PC, so just
Yes, Your Honor.
tell me your ideas on bond.
5 million.
Yes, Your Honor. And with those allegations in the PC affidavit, we do have an elevated fear for the safety of the community. We also we're looking at the prior history from Mr. Angulo. And
He has prior history.
we have some that look like they could be priors with his with an alternative name, but it does not. There's nothing no confirmed prior history, Your Honor.
Okay.
So we would stick our argument on the danger to community for a cash surety property bond.
People, I mean, defense.
Yes, Your Honor, I would be asking for a supervised PR bond or a lower than scheduled cash surety bond in this case. I don't see any indication that Mr. Angulo has any prior criminal history. I do think that typically they do look for aliases and nothing was found by pretrial services. I believe that Mr. Angulo is employed as a manager at Burger King, and he has been here in the area for some time now and has a home here. So I think that he has strong ties to the community and would be motivated to stay here and resolve this case. And again, I would just remind the court that although the allegations are serious, they are at this point allegations, and Mr. Angulo's lack of prior criminal history and steady employment should be considered in setting a lower bond or supervised personal recognizance bond in his case.
Court has read the PC affidavit. Given what I would call a pattern of conduct in this case, this is not an isolated incident, it's a pattern of conduct. I am not going to grant a PR bond.
May I add something, Your Honor?
You better be very careful about that because they can use anything you say against you.
Due to mental health concerns, it would be better in my interest to go home to my emotional support animals, which are abandoned at this moment. They are a huge benefit for me and being on my best behavior.
Nobody cares.
If I
Shut
lose
up.
my dogs due to their abandonment, if they starve to death, it would be a huge blow to my mental health.
Well, that would be unfortunate, but what?
Protection order on this one, like the one.
Yeah. Bond is set in the amount of $50,000. There is a mandatory protection order, so you're not to have any contact with anyone under the age of 18.
Yeah, but he works at Burger King, sir.
So was I granted a PR bond?
No, it's 50,000 cash, surety. There is no PR. Next court date?
Never.
6
No
at
court
1:30
date.
p.m. in Division DST.
Thank you. Deputies, is that it?
That would appear to be it.
Okay. See you tomorrow.
Yes, sir.
This was from last week. And honest to God, I do not remember if we've seen any of this before. So here's what I'm going to do. Let's start here. And if we run out of cases, then I'll go back to the beginning. But I don't think we will. No, you're right, Donald. It should be 500,000.
Let me go tell her that. So basically, we have to wait for that.
Well, ultimately, it's the 2/30th that would enter in the judgment to the clerk's office, who would send it to the sheriff's office. So until judge signs it, sends the clerk, then sends it to the sheriff's office, I can't do anything.
Okay, I'll tell her that.
Okay.
After Mr. Hill.
Yeah.
Morning, Mr. Hill.
Good morning.
How are you?
I'm good.
So,
Feel like potatoes are involved.
they're telling me that you have an open case out of another state. That's why we have the fugitive hold on you at this point. It looks that you are wanted out of the state of Mississippi. Is it Oktibbeha?
Oktibbeha. Yeah, I'm not going to pronounce it accurately.
Or
I can spell it.
robbery, violation of a court order. Is that correct?
Yes.
Okay. You have two different options.
Like I said,
You can waive extradition or you can fight extradition. When you fight extradition, it's very, very limited on what you can't fight. We don't really, it doesn't matter what happened over there. You know, the only thing that matters is if it's you. If it's you, then we wait. There are several ways that we can go about it. You can waive extradition, which when you waive, traditionally we give the demanding jurisdiction here in Mississippi 2 weeks to come get you. If they don't come get you within the 2 weeks, normally Harris County releases you or releases the hold. The problem in your case, though, is that you also have a felony assault that you've picked up that you have not made bond on. Because you have not made bond on that case, the 2 weeks or the waiting period that we traditionally give to them is on hold. That it gets put on hold until you make bond in that felony case or you resolve it upstairs. Once that happens, that's when the time for Mississippi to come get you is triggered. But that is assuming if you want to waive. Your other option is to fight extradition, in which case they will get a governor's warrant, put on evidence to prove you are you, which is the person that's wanted out of Oklahoma. And there are several ways that they can do that. And we have a hearing to do that. We need to know what you want to do, whether you want to fight extradition. You don't have to tell me right now. I just wanted to bring you out here to explain to you what your options are so that we're all on the same page. You know, unfortunately now, just because that case upstairs, everything's just basically just put on hold until you take care of that. Or if you make bond on that case. Do you have any questions?
I do have questions.
Okay, let's not talk about your case upstairs. You know, you have the right to remain silent. Anything you say can or will be used against you. I guess it's bad of me to ask if you have questions. You should probably ask the questions to your lawyer first, and then she can, you know, I guess talk to me. Because I don't want you to say something that.
Or by my social. NCI.
So I think the question is, Judge, he is basically stating that this is not correctly connected to him because the documents that he has seen have the wrong social security number on there. And I've explained to him that that is one of many ways that you can be identified as far as fugitive is concerned, and that that is a matter of a clerical error that they will remedy. And so that's not going to keep you from being extradited. So is there a question in line with that you want us to ask the judge?
Okay, so on my original social security number, I don't have anything connected to my background on my original birth social security. So when an NCIC check is ran on my background, they have to use another social security number to find me
Well, there's several ways that they can find you. You know, it doesn't have to be just that. They could use an FBI number, an SO number, you know, date of birth, driver's license. There's just so many ways that they can try to find you when they run an NCIC. But here, really, what matters is, are you the Fajon Hill that is wanted out of Mississippi, right? And the way that they use that or determine, they use pen packets, they'll use fingerprint cards, they'll use mug shots, so they could use any number of ways to identify, to put two and two together that is actually you.
Okay. So I can't prove or bring evidence.
No. I can't give you advice. So what I'll do is I'll direct you to, you know, Chablis, who can tell you exactly what. But like I said, the two options you have, you can waive or you can fight in the event that you do want to fight, which is okay. I mean, you're not going to hurt anybody's feelings. You're not, you know, you need to do what's best for you at the end of the day. Understand that they will go get a governor's warrant. It's a big packet of information to prove that it's you. They get an order, you know, basically to kind of remand you back to Mississippi.
All right. One more question. Can y'all simply put a charge on a record that I haven't been charged with? Can y'all charge me with something that's not on my record that I haven't been charged with?
Yes, you get charged. That's how it
So
gets on your
basically
record.
what I'm asking is, if I don't have something on my record, can y'all just simply put it up on there?
No, of course not. We don't put stuff. No one, I mean, DAs are the ones. So, you know, traditionally what happens is when you pick up a case, an officer goes, investigates. When they determine that there's enough probable cause or whatever it may be that a crime has occurred, they call the DA's office, the intake division. They give the version of what happened, right? And the DAs are the ones that decide whether to accept a charge or whether to not accept a charge. If they, you know, don't want to take the charge, they tell the person, go beat rocks, you know, get out of here. We're not taking anything, right? Or they say, okay, well, this is a good case, you know, initiate everything of, you know, initiate a case, issue a warrant. In this case, this is from Mississippi, so I have no idea what happened over there. The only thing I know is that there is an open robbery. Do you have any information more?
No, but they confirmed the teletype that it is this defendant. And so, I mean, with the confirmation that we have, obviously, if we go to the governor's warrant, then the state has 90 days for us to get the governor's warrant while he's in custody for us to verify. We'll get a fingerprint expert and we'll have a hearing.
That's traditionally how it goes. Whenever anyone wants to fight extradition, they get fingerprints. They get an expert to prove, hey, these are your prints here, right? Because they'll match it to when you got arrested here, because they took your prints when you got arrested, right? So they'll take that one, match it with these fingerprints here to prove that it's actually you. And that's how we determine who that person is. Now, it may not be you. I don't know.
So what about the mistake they have made though?
Yeah, what about the social security number? Dude, you're beating a dead horse with that. Let it go.
Well,
They
like
have made a
Chip
mistake.
said, people make mistakes. We're all human, if maybe they put a wrong 2 instead of a 6 or something like that. I don't,
So that means
there are other ways to look. We never want to hold the wrong person.
Mm-hmm.
We don't do that. We're not here to play games. We
I've
don't
often held
hold
the wrong
people
person.
for the sake of holding people.
Yeah.
We only want the right person. That's all we want. We're not here to play games, right? It's either you or it's not you. I don't know. But if it's not, we'll have a hearing to determine whether it is or not. But at the end of the day, we don't hold people just for this, shots and giggles. It's not what we do. So I'll give you guys, time to talk. If you want to waive, we'll just have you sign the waiver. But like I said, the 14 days kicks in as soon as that hold upstairs is released. The hold can either be released by, you taking care of that case or someone posting your bond. The bond now is set at $15,000. That's the long and short of it. So, and you don't have to decide today. If you want more time, we can roll you for a couple days to take your time to think about it. There's no rush, whatever you want to do.
You can come back next week after you said that your other attorney was gonna give you an examining trial. So if we put it toward the end of the week.
It's towards the end of the week.
No, I'm saying if he does do it, I can reset this one to closer to the end of next week. So then based on what that lawyer tells you about the case upstairs, we can decide if you want to bond out, if you want them to post a bond or if they're gonna dismiss it. And then the 14 days will kick in shortly thereafter. That way you're not just sitting here.
Okay.
I don't show that it's set for an examining trial. I show
But that's what I told him already, but he's saying that he had a conversation with the lawyer and the lawyer was gonna put it back.
So let's not, I don't want to, I don't want to get that all out in here because you guys, you have a privilege with your lawyer up there and we don't need to know about it. You need to handle your stuff upstairs, what you got going. So I'm going to have them put you back. If you don't want to take care of it today, it's okay. We can roll it for a couple days next week, later this week, whatever you want to do. There's just no rush. Okay? All right. Good luck, Mr. Hill.
I'll check with Brianna in case.
So in the event that he wants to waive, just file it. Let me have it and I'll sign it. We don't need to bring him back up if he wants to.
Yes, sir.
And there's no rush. Whatever you guys want.
Did you sign the other one?
On Melons?
Yeah.
What about?
I checked the judgments and the clerk's queue. Well,
I know you rely on your client to come up with this information.
I should unmute. So I feel strongly we saw that. We just saw it. We saw it. I played the wrong clip. So I have a plan that I'm putting in action. I'm just gonna pick a clip that I've never ever seen before and see if it's got anything good for the last 30 minutes. And hopefully, hopefully there's something good in here. It doesn't look like it. This is Connecticut. They get very lawyer-y lawyery in Connecticut a lot of the times. Sometimes it's crazy. The whole beep, 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 beep videos or blank, blank, blank. The whole blank, 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 blank videos came from Connecticut. Remember that one? Do you want me to read it to you again? But a lot of times it's just lawyers. So, but I have other clips that we can switch to. Don't worry. Yeah. There. Oh, I definitely have that judge in these that I haven't looked at yet. But let's see what Connecticut gives us. This guy doesn't look like a lawyer, and she definitely does not look like a lawyer because you don't wear hoodies to court if you're a lawyer.
What do you want to do?
To be honest with you, I'm not 100% sure, Your Honor, how we should proceed. Obviously, we would like to get good service. So would this be able to be marked over perhaps, and we could investigate it and perhaps get service at another address? Would that be possible? Or I just don't, I'm not even 100%.
I can mark it over, but trust me, there's going to be an electronic note in the file that this is not good service.
Yeah, I understand.
This is the wrong. So your client's not going to get what they're hoping for. I do note that the car was originally bought, and the loan was apparently originally transacted in Maryland.
Yes.
So I'm sure in the continental United States, there are probably many Michael Lees. I will mark it over once, but it is possible your client simply has bad information. I want to thank you, Mr. Michael Darnell Lee, for appearing today to clarify this. And I'm going to mark it over, but you need not show up on the next court date, sir.
Okay, thank you very much.
Thank you.
Appreciate it.
Your Honor, may I just ask Mr. Lee? Oh, I'm sorry.
Sure.
Would it be possible, Mr. Lee, do you have a telephone number? Can I contact you just so we can confirm that information? I totally take you at your word.
Hang on. Now, here's what's not going to happen.
Okay.
Because we're live streaming on YouTube and on the record, I'm not going to make anyone give their private phone numbers.
Just their social security number.
What can happen is you can request him to call you. Your number should be, I'm sure, at the bottom of the legal documents that were left at his house. Yep. It's on there somewhere, trust me, Mr. Lee. If it's not on this side, it's at the bottom of the signature page.
I have it right here in front of me.
Right above my signature.
Yeah.
Right above my signature on the first page, sir.
Okay.
So your name is
Toby Rhinesmith. It's that kind of scribbling looking, that's my signature. Right above there, it says telephone number.
Okay, I see it. Yep, I see it.
Please give us a call, just so we can, I 100% believe you, but just so we can confirm that and we can just make sure that we want to make sure we are serving the right person, so.
Right, yeah, definitely don't need to have any more of these coming to my house. So
yeah, but that was the address that was provided to our client, so we just want to make sure that, we can clear that all up.
Sure. And when do you know when you'll be available for me to call?
You can call anytime, sir.
Okay.
Well, you can't call now, counsel.
Right, that's what I'm saying.
Yeah, anytime this afternoon, tomorrow. What about we say tomorrow? Can you call tomorrow?
Okay. Yeah, I'll give
Okay, and you can always ask for myself. My name is Toby Rhinesmith, or anyone else at our firm can help you out as well.
Okay, no problem.
All right. Have a great day, sir.
Thank you.
Thank you
very much.
And Madam Clerk, we're continuing this. I think we better give counsel 4 or 5 weeks to try to get more information from this client. What date would you like to suggest?
5 weeks, Your Honor, is March 13th. We have availability at 11 a.m.
All right, March 13th. 11 a.m. All right, matters continued to that date. Thank you. Papa v. Papa.
Good morning, Your Honor. Catherine Scanlon for Reardon Scanlon for Barbara Papa through her conservator, Frank Coulomb.
Thank you. And is Barbara Papa here, or is anyone here speaking on behalf of the unserved defendant, which is successor trustee of the revocable trust of Sebastian Papa. Anyone here as to any of these? Record reflect no answer. Counsel, I'm going to take the papers. I've reviewed the papers. I anticipate granting both the temporary injunction and PJR. I do find service sufficient since it was refused by Susan Papa, according to the records of the U.S. Postal Service. And it's not in the defendant's province to avoid service by simply refusing it. But I will point out that since the unknown successor trustee was not served, since there does not appear to have been an attempt to serve anybody as the potential trustee, including Attorney Scalise, or by notice of publication, my orders will be limited to Ms. Susan Papa, just so we're clear.
Thank you. I appreciate that. And I would just add one thing for the court to consider. And again, thank you. It is that, as the court can see from the papers, there is a concerted effort to abscond with monies and with property and to prevent the successor trustee from being known. Outside of the record, we believe that Susan Papa is the successor trustee, and though we haven't alleged that because we didn't know that in December, could the court consider fashioning its orders because Susan Papa was properly served to pertain to Susan Papa in any capacity? She's received notice to the extent that she is a successor trustee, that relief be granted to prevent her from acting as successor trustee to the extent she is. And that's because, Your Honor, we've made, prior to filing this and during the month of December, every single effort we could demanding information about this trust from Mr. Scalise and without avail until earlier this week when I finally received a letter from him indicating that Susan Papa is a successor trustee. So I just asked that the court consider that.
He has notified you that she is the successor trustee?
Yes.
Attorney Scalise, so you're representing as an officer of the court. You've been notified by Attorney Scalise that Susan Papa is the successor trustee?
Yes, Your Honor.
All right. Thank you. All right. Well, that changes things, and I will take that into account in fashioning my order. Thank you.
Thank you very much.
All right. Estate of Ferrara versus Pinata Landscape.
Good morning, Your Honor.
Pinata Landscape.
Good morning.
Good morning, Your Honor. So, as an update, Your Honor, there's been a number of
since the monitor's recording this, if you could identify yourself.
Sure. Yeah, Andrew Ranks for the plaintiff, Your Honor.
Thank you.
Audrey Med with Russo and Gould for the defendant.
Thank you. So where are we? You were trying to confirm the insurance coverage.
Yep. So there have been a couple of developments, Your Honor, in the time since we were last here. One, the defendant was recently arrested within the past week or so for this accident. He's been charged with negligent homicide as well as failure to maintain lane. That he hasn't had his first criminal hearing, and I still don't have the police report, but I expect to receive it any day. In light of the charges.
It's a misdemeanor, as you know, counsel, under the statutory scheme, and it would be highly unusual for someone charged with that to not be at liberty after their arraignment. But of course, I'm not prejudging how his arraignment will go. So, all right, that's number one. Number two, what about the insurance coverage?
With respect to the insurance coverage, in their defendant's objection, they had represented there was a $1 million AmGuard policy as well as a $5 million traveler's excess policy. Subsequent to the hearing, we received a disclaimer on the $5 million excess policy from Travelers. We have done an investigation to try and get the scope of that disclaimer, as well as to figure out just generally what was going on with respect to their insurance. I won't belabor the court with the coverage analysis because we're still undertaking it, but we've served a subpoena on the insurance agent for compliance by February 19th to produce all communications, all policy documents in order to, they had one agent that wrote both the AmGuard policy. There was a Travelers underlying policy and a Travelers excess policy. So we're in the process of obtaining those. So we need to assess the conduct of the agent and why it was written in the way it was written, and also evaluate the nature of the whether the coverage denial itself was proper.
All right. Well, the defendant, I assume you meant I'm sure you meant the driver of the vehicle, the defendant here being, as we all know, an LLC. I guess my question is, insurance coverage aside, that sounds as though there's, at the moment, apparently 1 million and potentially 6 million. Does anybody know if you obtained a prejudgment remedy, whether there's any assets worth seizing from Pineda Landscaping Services, LLC? In my limited experience, landscaping companies don't usually have a lot of assets unless you're interested in an old lawnmower or one of those trucks and drop tailgate trailers that seem prevalent in that industry. In other words, have you really thought through whether it makes sense to have a PJR hearing? I'm sure you have. Have you reached a conclusion on that?
Yeah, so I think having it scheduled would be helpful, Your Honor. And my expectation is that once we get the police report, I forwarded medical records, autopsy reports over to defense counsel, that if it turns out that there only is $1 million in coverage, I would hope that they would tender based on the facts of the case that we know already. And I would have to take that to my client. But I think scheduling the hearing in April would be appropriate. I have, I think, an obligation to just make sure that I know what I can find out about any assets if there's only 1 million in instead of 6 million in coverage.
I appreciate what you're saying. I normally wait to schedule a PJR hearing since we have limited availability until it's clear that one is needed and that and the plaintiff's counsel believes it makes practical sense to do it. I don't see anything in my notes indicating that I made any commitments as to when a PJR hearing would be. So in light of that, what I'm going to do is I'm going to continue this for another status conference to give you an opportunity to depose the insurance agent, see if that can clarify the situation. And if on the next date you are confident, or at least you believe that there's only $1 million in insurance and that there are some assets worth attaching, then we can go ahead with a PJR hearing. Madam Clerk, give me another status conference date, please.
How far out, Your Honor, would you like it?
I think counsel probably deserves, given that it's going to be a few weeks before he does his deposition and he's got to follow up, I'm thinking roughly 6 weeks. Attorney Ranks, what do you think?
I think that would be sufficient, Your Honor, yeah.
We were told by a very, very important person that we are a cult. So.
Okay. So let's go out about 6 weeks, and we need no longer hold that date open in March, Madam Clerk.
Your Honor, we have availability on March 13th at 11 a.m.
Okay, would you like March 13th at 11 a.m.? Does that work for both councils?
We can do that, Your Honor.
That works for me, Your Honor. Thank you.
You are quite welcome. I will see you then. And I'll make a note to myself to give you a PJR hearing date. Then as needed. All right. Thank you so much.
Thank you.
Thank you, Your Honor.
Thank you. Anderson versus Lanier Construction. Anderson versus Lanier Construction. Ms.
Morning, Your Honor.
Anderson.
Derek.
Present.
For-
All right. First of all, it's Anderson versus Lanier Construction. Ms. Anderson, you were here in a self-represented capacity, and an
Love it.
appearance
Let's
was
go.
just filed on behalf of Mr. Lanier by Attorney Donnelly, I take it.
Nope, you're all gonna have to get the shirt that I'm wearing today.
Yes, Your Honor, that's correct.
All right. So is Mr. I think it's Lanier Construction LLC. Are they opposing the application to discharge the mechanics lien?
Yes, Your Honor, for a variety of reasons, and I've only been retained this morning, but my brief research has already indicated that the plaintiff no longer owns the property. So we will be opposing the discharge of the mechanics lien and likely moving to dismiss based on a lack of standing.
Is that accurate, Ms. Anderson? You don't own this property anymore?
Yes, I closed on the 18th of December, but I also put money aside in escrow to clear this matter with the court.
All right. Let me point out a practical thing. I haven't done a lot of legal research, but my brief review of the file indicates that we're talking about $7,000. Attorney Donnelly, unless you're handling this pro bono, by the time you file a motion to dismiss and the attendant paperwork and argue it to the court, I would think at that point it's costing Lanier Construction LLC about as much in attorney's fees as they're claiming.
Well, Your Honor, without getting into the agreement specifically with my client with respect to fees, which I'd prefer to keep off the record.
Yeah, you don't have to tell me what your fee agreement is. I'm just trying to be pragmatic that a $7,000 claim is going to be eaten up in attorney's fees.
Your Honor, we plan to move to foreclose on the mechanics lien, and we believe that the new owner has title insurance, which should be covering this anyway. So, if Ms. Anderson is representing there's an escrow, there's certainly money out there to resolve this matter.
I agree with that. There is money out there to resolve the matter. The question is whether the attorney's fees for Lanier Construction are going to eat into his net recovery. Ms. Anderson, you set money aside. Have you had any settlement negotiations? I mean, I don't know why you're not happy. Maybe you're not happy with the quality of the work. He claims he supplied, I think it was $7,000 worth of flooring, if I recall correctly.
Your Honor, that is incorrect information to begin with. But what I am asserting is that, first of all, that the contract in itself is null and void. He also filed the original certification, meaning mechanics lien, in his own name, but then signed the document on the behalf of his LLC company, Lanier Construction. And if that doesn't change anything, then also Lanier Construction did not comply with the Home Improvement Act, which requires certain things to be on the contract in itself. One, it's
ma'am, I understand. What I'm not hearing is that you're dissatisfied with the work or that the work was never done. I'm hearing a lot of technical defenses that a lawyer might successfully raise, and perhaps you will too. I don't know. that wasn't my question. I'm
Real
sorry
lawyer.
if I was unclear. For $7,000, have you had any discussions about a number between $0 and $7,000 to resolve this? And are you open to such a discussion?
Your Honor, he did not supply $7,000 of anything.
That wasn't my question. My question is,
I am hoping to negotiate something, but
thank
certainly
you.
$7,000.
Well, 7,000, if you gave him everything he asked for, there wouldn't be much of a negotiation. I said a number between $0 and $7,000. Here's what we're going to do. The two of you are going to have settlement discussions before the litigation posture of this case and the potential foreclosure of the mechanics lien basically put the attorney's fees at such a point that it becomes impossible to resolve it. So I'm going to mark it over. You're going to have a discussion. If you're unable to resolve it, fine. You're entitled to be unable to resolve it. You're entitled to have a hearing. But if Attorney Donnelly files a motion to dismiss and he's successful, then that'll be the end of it.
Can you prove that?
If he files a motion to dismiss and he's unsuccessful, then you'll have to have a hearing on the motion to discharge mechanics lien. Madam Clerk, give me a date to allow some settlement discussions, or begrudgingly between the parties. What date are you suggesting, Madam Clerk?
Your Honor, 7 weeks out, is that a good time frame?
Yeah, 6 weeks, 7 weeks. I'm looking to you to suggest a date. We do have that additional date that's opened up in March.
Yes, Your Honor. We are able to schedule March 20th at 10 a.m.
Fine. March, yeah, I'm sorry, turn it out.
I'm not available that day, Your Honor. I'm sorry. If we could go a little
What
farther.
about the prior week? No, let's go earlier. The prior week?
I have a trial, Your Honor, in Waterbury, followed by, or I have a trial in Middletown, followed by a trial in Waterbury. So I think the earliest I could do would be that following week, the week of the 24th.
Are those scheduled trials, or are they going to really happen? You and I believe know that a lot of times everybody knows a case scheduled for trial is gonna settle.
Yeah, I believe that Judge Cordani is going to make us go forward in the trial in Waterbury, Your Honor. So I certainly believe that week of I certainly believe I'll be tied up both of those weeks, Your Honor. So
all right, fine. Give me the next week then, Madam Clerk.
March 27th at 10 a.m. is available.
March 27th. And you're to have settlement negotiations between now and then. And if they're unsuccessful, Attorney Donnelly, you must file your motion to dismiss prior to that date.
Very good, Your Honor.
Okay. Thank you. Thank you, Ms. Anderson.
Thank you, Your Honor.
And I hope the two of you are able to work this out for both your sakes.
Thank you, Your
Thanks
Honor.
for nothing, Your Honor.
Now, moving on to the matter of, well, I will indicate for the record that we had Chaparelli Commissioner versus Jatobra was continued this morning at Council's request. They're apparently very close to having a full agreement. And LM General Insurance versus Al Noor Islamic Center all was continued. One of the attorneys has jury duty and cannot get out of jury duty. So for anybody listening, we really do treat everybody the same when it comes to jury duty. Moving to Witkowski versus Trinity Health.
Good morning, Your Honor.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Diana Carlino for Woodland Anesthesia.
Julianne Clausen for the for the Trinity defendants and St. Francis. Sorry, we're talking over each other. Julianne Clausen from Risk-Cassian Davis for the estate of Dale Burns.
Thank you, each of you. As I recall, this the bill of discovery, they're looking for a TEE. And the result, and they couldn't find it. As I recall, there were technical problems. Again, it's been a while since we talked. And there was going to be an effort to try to resolve those. Either they can find it or they can't. If they cannot, I can grant the bill of discovery, I suppose, but I don't think that gets you anywhere. If they can, then they were going to turn it over. Who would like to speak on behalf of the defendants in that regard?
I will, Your Honor. I have been in contact with the client. They have done their due diligence trying to figure out what happened with this TEE. And what I am being told is that the intraoperative TEEs are not saved because they're not diagnostic TEEs, but they're used for intraoperative monitoring only. So the TEE in question doesn't exist. I have conveyed this information to plaintiff's counsel and to the co-defendant. I am happy to provide an affidavit to that effect if it becomes necessary, but the document or the imaging in question doesn't exist.
Was not saved. It existed at some point.
It did exist at some point for monitoring purposes. It's not all that dissimilar to ultrasounds done during labor and delivery, but that's where we are.
And I think it's probably plaintiff's counsel who should address the issue next. What do you, I mean, do you have any reason to disbelieve Attorney Stefanato's client's version of events? And will you be satisfied with a detailed affidavit setting forth what her clients told her? From her client, obviously, not from counsel.
Yes, Your Honor. The affidavit will suffice.
What are we going to do then with the bill of discovery? Are we simply going to mark it off, or?
I think what would be helpful from the court is perhaps establishing a deadline for that affidavit, and then we will withdraw our bill of discovery upon receipt of that.
That sounds good. Thank you for that suggestion. Anybody have a problem with that concept? Hearing none, what's a reasonable date? And Attorney Carlino, you're billing, so I don't mean to cut you off. But I think the burden's going to fall on Attorney Stepanatos to get an affidavit from our client. How long would you like to do that?
If I could have 3 to 4 weeks, Your Honor, I would appreciate that. And the only reason I ask for that much time is because I'm going to be away.
That's that. You don't have to go into detail. I think 3 to 4 months is reasonable. I'm not hearing any objection. All right. So here's what we're going to do. 1, I'm going to mark this off this calendar. 2, I'm going to give 4 weeks to Attorney Stepanatos to produce the affidavit from her client indicating that the TEE was not saved, and so that no copy of it exists, or whatever technical term they want to use. And 3, I'm going to tell Case Flow to look for Attorney Clausen to file a withdrawal in approximately 6 weeks. And believe me, they will. And they'll reach out to you if they don't get one by then. Your office is familiar with that, I'm sure.
My money doesn't fold it, jingle jingles.
All right. Anything more I can do for counsel today?
No, Your Honor.
Thank you.
Your
Honor, thank you.
Okay, I know. I liked all these. I liked this Connecticut one. And I think Peg Leg did too, but I know it wasn't the best for everybody else. But we made it to 2 hours, and we learned a little bit. And I have OJ set up. Guys, just so you know, once we're done with OJ tomorrow morning, right, we will have done 2 full months of a court hearing. OJ Simpson. We're not close to the end, but we will have 2 full months in. Martha, go get drunk today because it's your birthday. It's Martha's birthday, guys. How could you not pay attention? It was lawyerly talking. It wasn't crazy people talking. Another Smith, it's always great to see you. Thanks for coming. We got everybody in today. This was a great chat. We had everybody in that hasn't been for a while. Not everybody, but a lot of people. Chad. Okay. All right. It's going to pop you right over to OJ. And, you know, it's going to start getting good. It's going to start getting good, guys. Thanks for coming. I shall see you all. Listen, I have off today. So I might see you soon. I might not see you soon. Who knows if sleep will take me. If sleep doesn't take me, I might do something in the middle of the day. Maybe a members only. I don't know. I can do whatever I want. So maybe I'll see you soon. Maybe I'll see you in Bill's. Maybe I'll see you tomorrow. But I'll definitely see you in OJ. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Street tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray,